This is Catherine Fellman reporting on the First Amendment right of freedom of speech as brought about by the case of Pickering versus the Board of Education in Township, Illinois, 1968. What led to this lawsuit began in February 1961 when the Township Board of Education asked the voters to approve a bond issue to build 2 new schools. It was defeated. However, the second time it was put before the voters, it passed in December of the same year. 3 years later, in May of 1964, the board proposed a tax increase for educational purposes. It was defeated, but later in September of the same year, it was again proposed and defeated. Prior to the September vote, letters written to the editor of the paper, one from the superintendent and others which were attributed to the teacher organization in the 205 district, urged voters to say yes to the tax increase because if it failed to pass, the quality of their children's education would decline. Pickering, a high school science teacher in the district, responded with a letter of his own, stating that much of the money received from the 1961 proposal was allocated to the athletic program instead of being used as promised. He then went on to say that the superintendent and the board tried to prevent teachers from speaking out against the proposed bond issue. He was subsequently fired for his comments. Because of Illinois law, the board held a hearing justifying the dismissal of Mr. Pickering. They had determined that he lied and that he had impugned the integrity and competence of both the board and the superintendent, and that his comments interfered with his duties and the functionality of the school. Pickering then decided to sue the board on the grounds that they had violated his First and 14th Amendment rights regarding free speech. He began his journey in the Will County Circuit Court, which agreed with the board. He then appealed his case to the Illinois State Supreme Court, which upheld the ruling of the Circuit Court. Finally, he took his case to the United States Supreme Court, where the court ruled 8-1 that his First Amendment right had been violated. The litigants in this case are the claimant, Marvin L. Pickering, a high school science teacher in School District 205, and the defendant, the Board of Education of Township High School District 205 in Will County, Illinois. The facts of the case are as follows. The board fired the teacher because he wrote a letter to the newspaper. The letter criticized the board and superintendent for misleading the public. The board accused Pickering of false and damaging accusations. Pickering claimed violation of his First and 14th Amendment rights regarding freedom of speech when he was terminated. He then sued the Board of Education, beginning in Will County Court, going on to the Illinois State Supreme Court and the United States Supreme Court. The issue at hand was whether school officials violate the First Amendment by terminating a teacher for writing a letter to the editor of a newspaper that discusses important matter of public concern. The Supreme Court determined that Pickering did not knowingly make false statements regarding the allocation of funds. He also did not hinder the school's ability to continue with its daily functions as set forth by the case of the New York Times Company versus Sullivan in 1964. They did determine his First and 14th Amendment rights were violated as set forth by the Keishian versus the Board of Regents in 1967 when he was fired for making statements as a concerned citizen. The court held by an 8-1 vote that schools do violate a teacher's First Amendment right when they terminate employment because the employee speaks out as a concerned citizen regarding the school. The majority opinion was written and read by Justice Thurgood Marshall. He stated, while criminal sanctions and damage awards have a somewhat different impact on the exercise of the right to freedom of speech from dismissal from employment, it is apparent that the threat of dismissal from public employment is nonetheless a potent means of inhibiting speech. The impact on education in this case is evident because public school employees are entitled to some First Amendment protection when they are acting as private citizens. especially when the remarks are not intended to harm the district or people for whom they work. This case is important because it demonstrates to our students the importance of being a participant in the voting process and the value of protecting every person's right to speak freely. My resources are the First Amendment Center, which can be found at thefirstamentmentschools.org. Also from the U.S. cases that you can find at the Civil Liberties website, the Supreme Court, which you can find from justia.com.